In the comedy Raising Arizona, a young child is kidnapped, and at one point this rather gruff character shows up on a motorcycle. He's obviously like a bounty hunter. And he tells the father, he says, listen, hire me and I'll find your child for you. The father says, why should I hire you? We have the police working on this. Guy looks at him and he says, if you hire me, I'll find your child. If you want to find Dunkin' Donuts, stay with the police. Now that's a funny line. How can I bring that back to living trusts? I'm sure you have all seen ads in newspapers inviting you to a free breakfast, a free lunch, to discuss living trusts. Those are sponsored by people who want to sell you a living trust. And indeed, they will give you a donut. My advice is if you want a living trust, go to a lawyer. That will be done right. If you want a donut, go to such a seminar. Why do I say you should go to a lawyer? First of all, I've talked to a lot of elder law lawyers, and they tell me people will come in with these very fancy documents that they got at a seminar like that, and they're in colored paper and they're fancy binders, but they don't make any sense. And it is their view that like 9 out of 10 of these people who spent $1,200, $1,500 for a living trust didn't have to spend that money because they didn't need a living trust. They could have another document. There are several legal documents that can achieve the goals the living trust does. Often much easier and much less expensive. But the main reason is that lawyers will be there if you have problems downstream. If you want to change any of the provisions, they'll be there. And we'll see in a moment that one form doesn't fit all. Let me tell you though, on the other hand, living trusts can be very, very helpful. First of all, as we will see momentarily, they can take care of the problem of incompetence. If parties become unable, lack mental capacity to deal with their financial affairs, living trusts can be used to take care of that. They can also be used as a will substitute. And if your property is in a living trust, when you die, it doesn't go through probate. And that can save a lot of heartache, a lot of time, and also a lot of money. What I'm going to do now is go through a kind of a made-up short form of a living trust so you can get a feel for what they actually are. This trust is for the benefit of Dick and Jane, husband and wife, and shall be administered by them. Now, like me, you probably have always wondered whatever happened to Dick and Jane, and now you know. They are happily living thereafter, but now they decided to have a living trust. But notice that it is administered by them. And basically that means that they make all of the decisions, what to do with the property, what to do with the income. Like nothing really has changed in their daily lives with a living trust. If they become incapable of administering this trust, it shall be administered by their son Jughead. Now, this is the provision that takes care of possible incapacity. If both Dick and Jane become unable to deal with their financial affairs, they will either have to have filled out a durable power of financial affairs, which I'll talk about in another segment. If they don't have that, and they have property and they have bank accounts, the relatives will have to go to court for a guardianship. And that can be quite expensive and can be heartbreaking. So this provision takes care of that. Now, at the death of either Dick or Jane, this trust becomes irrevocable. And that means prior to that time, you can revoke it, you can take all the property out and do what you want. But once one of the parties dies, then it's irrevocable and it's kind of set in stone. In the video segment on remarriage, you'll see why that is important under certain circumstances. Thereafter, the assets of the trust shall be used for the benefit of the survivor. And that obviously, like the income and the property, can be used for the surviving spouse. That, however, raises problems a lawyer can help you with. Does that mean, to what degree should the trustee be able to invade principal to help the surviving spouse? Obviously for medical things, but what about buying a vacation home, say in San Diego? What if the surviving spouse remarries? Are there going to be any limits, or are there going to be any discussion of that? And that's why a lawyer should be talked to, and you can tailor your living trust to take care of those problems. At the death of the survivor, the assets shall be administered in equal parts to the then surviving children of Dick or Jane. Now, that's pretty simple. Here it's acting as a will substitute. But again, there are problems with it. Say, for example, that Jughead dies before the last, either Dick or Jane. That means, as this is written, his children would get nothing. It would go to his brothers and sisters. Well, do you want that to happen or not? Now, a good lawyer can draft around that, and you can talk about what do you want to have happen in those cases. And there are a lot of creative things you can do in these situations. And again, that's why you got to talk to a lawyer about this who will see. When you read this language, it makes perfect sense. But lawyers are trained to see kind of the hidden problems and to help you with them come to the solution that's best for you and for your family. Let me conclude with a few words on the benefits of formality. Wills, I'm sure you've all heard, start off with being of sound mind, blah, 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 blah. And a lot of people make fun of that. However, you've got to realize that these documents that you sign are going to have a big impact, not only on you, but your children and your grandchildren as well. So take it very, very seriously. This is not something to fill out when you are high on a lot of sugar donuts. Good luck.